Welcome to Cross-Border Tax Talks, where we discuss the latest trends in international taxation, from global tax policy to the OECD's latest developments. I'm Doug McHoney, PwC's International Tax Services Global Leader. PwC's Pillar 2 engine, powered by Beacon, is a game changer for Pillar 2 compliance, provision, and modeling calculations. Built on a graph system utilizing over 20 years of international tax technology, this cloud-based centralized rules engine is developed by a team of Pillar 2 tax experts from around the globe. PwC's Pillar 2 engine is currently available as a service and is also available to license. On this week's episode of Cross-Border Tax Talks, we're at PwC's Asia Pacific Global Tax Symposium in Hong Kong, where I'm excited to welcome Will Morris back to the podcast. Will is PwC's Washington, D.C. based global tax policy leader who spends as much time in his hometown as I do. Will, welcome back to the podcast.
It's a pleasure, Doug, although why you keep inviting me back is beyond me.
Well, we've got a lot to talk about, and we're going to focus here on Pillar 2. I've got no baseball. We're just going to dive right into it. You were in Europe 2 weeks ago, in Salzburg, Austria. We were in Japan together last week. We're in Hong Kong together this week, racking up frequent flyer miles, talking to taxpayers and clients from around the globe. Will, what are the themes you're hearing from taxpayers as we approach, in 40 days, the first June 30 filing deadlines for 2024 calendar year filers that are in scope of Pillar 2?
Well, let me put this politely. There is a heightened level of anxiety, a very heightened level of anxiety about the GIR, about the local filings, about QDMTTs, basically about the whole shooting match. It seems that not everything is completely ready.
I've been working on this for 4 years, Will, and we have been trying really hard to make sure that our clients and taxpayers are ready. And there's a lot of challenges, but maybe, and I'm going to kind of go through them, and particularly the recent common understanding document, so-called common understanding document that the OECD put out. But if you had one word to describe, and I'll give you more than one word, the Pillar 2 implementation process, what would it be?
Okay, well, I'm a polite chap, but I'm going to take three. But it is, what the heck? It really is. People are just totally scrambled by what's going on. They have no idea. There is, everything is swirling around. So it really is what the heck.
That was not the answer I was expecting, but there are a lot of questions, and people don't know what to do.
It is a what the heck.
It is a what the heck moment. So on May 18th, 2026, less than 6 weeks before the first Pillar 2 filing deadlines, the OECD released a document entitled The Global Minimum Tax, Support for Central Globe Information Return Filings and Exchange, (paren 2024 Reporting Fiscal Year, close paren), a so-called common understanding document. Not administrative guidance, a common understanding document. The document reads in part, and I'm going to quote because I think it's important for listeners, 37 jurisdictions have implemented a qualified income inclusion rule or a qualified domestic minimum top-up tax, which applies to in-scope multinational enterprises with effect from their 2024 fiscal year. As the due date for GIR filing approaches, it is anticipated that some of these 2024 implementing jurisdictions may not have a fully operational GIR filing portal in place in time for M&E groups to timely file the GIR in that jurisdiction. Furthermore, while it is anticipated that the exchange relationships between 2024 implementing jurisdictions would be in effect by the end of this year, M&E groups may not have certainty on this by the relevant GIR filing deadline, and jurisdictions may not be able to formally activate these relationships under the GIR MCAA before the relevant GIR filing deadline. I'm going to step away and make an observation here, that there are over a dozen countries that have not either signed or ratified the MCAA into law when this document was published. Back to the text. In recognition of the compliance and coordination challenges that could arise from a jurisdiction's delay in making available a reliable filing portal or in activating exchange relationships, the 2024 implementing jurisdictions have agreed that they will use mechanisms to the extent available under their respective domestic laws. I'm going to repeat this. Implementing jurisdictions have agreed that they will use mechanisms to the extent available under their respective domestic laws in order to Number one, waive penalties that might otherwise apply in respect of their local GIR filing, or not enforce their local GIR filing obligation before the relevant GIR exchange deadline. Where the GIR has been centrally filed in any one of the jurisdictions listed in the annex by the relevant filing deadline, and the GIR notification has been filed in the local jurisdiction by the relevant deadline. And then the annex then lists 33 countries that are, quote, jurisdictions expected to be ready for central filing before 31 May 2026. So let me pause here, and what does this tell us? In theory, this tells us that taxpayers that file the GIR in one of the 33 countries in the annex should not have penalties or risk waiving elections, in theory, in another country if that country hasn't either signed the MCAA or does not have a fully operational GIR filing portal. So taxpayers need to file only one GIR, in theory, just one. Okay. Note that I say in theory because a number of these countries may not be able to waive penalties or elections under their domestic laws, which the OECD acknowledges. They said, to the extent available under their respective domestic laws. So let's break down now the common understanding. The annex, the list of jurisdictions expected to have a fully operational GIR filing portal in place by 31 May 2026, includes jurisdictions that haven't released anything related to the GIR at this point. Nothing. Barbados has not released any guidance on the GIR filings, and the GIR filing is optional in Turkey. There's no portal for filing on XML, and if it's filed in Turkey, it needs to be attached to the local top-up tax return. We're working with global PwC teams and taxing authorities all over the world, doing our best to help our clients comply. Other jurisdictions that we are not aware of having any testing filing portal open or any guidance instructions on transmission for the GIR include the following, and these are on the list that are supposed to be ready in 2 weeks: Croatia, Gibraltar, Greece, Portugal, Romania, Slovenia. I'll also mention Vietnam, which is not part of the OECD list, but Vietnam is similar to Turkey in that they require essentially a local version of the GIR as part of their top-up tax return. How we file a local GIR and attach it when it's not really a form, it's an XML schema, all questions that remain unanswered. Many other jurisdictions still don't have a final submission portal open, including HMRC, who have said they will open it this week. Or even if they do, we'll still be working with the teams on the ground and their taxing authorities to determine validations and transmittal processes. So it's not just enough for them to open this up. We actually have to validate the actual filings to be able to then submit them with the respective governments. And this takes time for any taxpayer, any service provider, or any technology company to build and validate. I believe that this document from the OECD also confirms, which is not good news for taxpayers, that local GIR filings will most likely be due, if they can even be filed, in the Bahamas, North Macedonia, Slovakia, and Vietnam, as well as possibly Cyprus, plus Greece and Poland if the UPE GIR is filed outside of the EU. I will apologize if any of the countries that I've mentioned have submitted something since we published this. This is a very dynamic process. Another important thing to note, there are differences between the GIR XMLs between countries. How are governments actually going to share these in the timeline required? Korea, for example, has a different element in its GIR schema for the rest of the world. If we tried to add this to the UK, for example, it will fail the validation. How these countries actually submit different XML schemas between themselves to meet the relevant timelines remains unknown. Now, this tells us nothing about the other returns for Pillar 2, where the tax liability and tax is actually required. The GIR is an informational return. And these forms are widely disparate between countries, but they include, as Will mentioned, the so-called top-up tax returns. These are income inclusion rule returns and QDMTT returns. This guidance tells us nothing about those returns, only about the GIR, which again is in theory an informational return. A quick data point. As of May 6, so a couple weeks ago, we had 18 countries where either the non-GIR Pillar 2 compliance form, so that can be again the top-up tax return, the IR returns, or the QDMTT return, or the filing functionality, so and or the filing functionality is still pending. So that's 18 of the 37 countries. One of those forms or the functionality, we still don't know. So Will, I first want to thank you for your patience.
My pleasure.
For that diatribe. And I'm very passionate about serving our clients and have been working on this for a very long time. And I have concern we cannot rely on this OECD common understanding document. It is not administrative guidance. It is not law. The OECD acknowledges that each country still, to the extent of their law. What do you make of this?
Look, I mean, it's a great question. As you know, I was very close to the OECD for 10 years during BEPS 1.0 and BEPS 2.0. There is a pattern. I'm going to be generous here. I think that what the OECD does is always assume that the very best is going to happen. It's Pollyanna on steroids, if you will. And therefore, you know, in the common understanding, they hope that all of this stuff will happen. Now, experience, unfortunately, at this point, would tell you that almost certainly this is not going to happen. And as you know, another of my favorite phrases, which I've used on this show and others, is that most of these problems were totally foreseeable, but apparently totally unforeseen. And as you say, coming, you know, with a solution, which is a plan for a solution 40 days before some very important filings are due, which are giving our clients, you know, the taxpayers in many countries, terrible angst, is cutting it fine. And as you say, there is, in the end, nothing substantive there. The OECD cannot pass law. And, you know, the point that you make about administrative guidance versus a common understanding is also important, because obviously one of the things we've seen over the past year or so, all these questions about, well, is this stuff automatically incorporated into the EU? And if it is, then that's half the country's done, and, you know, that at least reduces it. Is, you know, common understanding, administrative guidance, does that qualify under the directive? Well,
I think if it would have, they would have included that in there. If they could have somehow made this administrative guidance, but that would have required unanimity, right, from the entire inclusive framework to get it out as administrative guidance.
Right. So, you know, I mean, they may yet make a push at the IF. They can do these things by paper if they want to. And, you know, maybe that works. But as you pointed out, there are a number of countries in different positions on this. So, you know, I think that I don't think you can take a huge amount of comfort from this. If every country, and some countries obviously do, but if every country had in its laws at least that they could waive penalties under certain circumstances, then that would give you penalty relief. But that still doesn't answer another of the crucial issues, which is if the law says that I have to elect a safe harbor by X date and I don't, then where's the relief for that? That relief doesn't exist.
And it's once the transitional, there's tons of different elections, but this is the one that's obviously the most concerning, is the one, and then you're once out, always out. Yep. So if you haven't filed the GIR because that country either doesn't have the exchange or hasn't signed the MCAA, then you're sunk from being able to use the transitional safe harbor and now have to do the full globe calculations in those jurisdictions.
And you know, what that means, this is a problem which very quickly begins to snowball, because one bad thing happens, which causes another bad thing to happen, which causes another bad thing to happen. And, you know, I hope we won't get there. It would be great if every country could get this sorted out, but the time is short. And, you know, I mean, obviously, they're not even at one level. They're not targeting, you know, the end of June. They're targeting the end of May, because realistically, you then need time to do stuff. And, you know, in some countries, many countries, there's a public holiday next Monday, for example. People will be taking a long weekend. There is a conflict going on in the Middle East, which is drawing some people's attention. So, you know, all of this stuff, as I said, it assumes that everything goes completely right. And the history of the past few years is that everything quite often goes quite wrong. So, you know, I think it's a shame. It is something that, I mean, and I will give you and your team all due credit for this. You have been talking to the OECD and to others about this for months and months and months. And it is only now that we are seeing, you know, a response to that, and a response which is, you know, perhaps it'll work, but honestly may not be fully adequate. And that is it's a real shame. Again, there are so many times at which this project could have been improved, opportunities were offered, and not taken.
Okay, I'm going to ask you this very directly. You've kind of alluded to it, but can taxpayers rely on this document to only file one Globe information return?
I don't believe so. I don't see how you can.
And I mean, listen, we're a part of one of the big four attest firms, big four accounting firms, right? We're tax lawyers by background and education. We can only advise on what the law says, right? Legally and under our standards as lawyers and accountants. And this is not law. And so we've seen a lot about this document being helpful, and I question how helpful this is. I will also say that you're right, the OECD did take our calls, and we have mentioned this, and we've been working with taxing authorities around the globe just to try to figure out exactly what their portals look like, what their filing process is, what we need to do, and they've been very engaging. But the problem is we're still at a point where we do not have, as I mentioned in my diatribe, where we do not have the forms or the portals available for companies to be able to comply.
Right, and I mean, let's be very clear about this. A lot of what we've talked about before has been the complexity of Pillar 2. This is nothing about the complexity of Pillar 2.
No.
This is about the complexity of the filing.
Just getting the forms.
That's right. And you know, the promise of this always was there will be one form which you file in one country. And actually what we find is many countries, probably where we're still going to have to file it. And also, you know, the GIR form itself doesn't alter between countries, but much of the rest of the information that you talked about in relation to QDMTTs, I mean, you know, countries enacted the law in different ways. I mean, you've previously used the example of how many times the UK actually, you know, sort of changed slightly, sensibly, undoubtedly, some of the definitions in their legislation. So that means that another form has to be filed. There is also the provision that sometimes you have to do some stuff on local GAAP, some stuff on parent company GAAP.
Absolutely.
Again, you know, 101 different things which have made this more complicated. And that original promise of, yes, we understand this is new. Yes, we understand you're going to have a new set of books. Yes, we understand this is modified financial accounting. But there will only be one model, and you'll be able to follow that across the world. That promise has not been fulfilled.
No, it has not. And there are examples of countries that I don't have the list in front of me that require separate QDMTT returns by constituent entity. And there are a number of taxpayers that operate in those jurisdictions. And I'm not going to mention those because I don't want to mention the wrong one. Right. But where, like for real estate, it's very common to set up a separate legal entity for every real estate holding that you have. And there are some where there could be hundreds of QDMTTs that need to be filed that all meet the transitional safe harbor,
right?
But no taxes due, but massive amounts of compliance that is required from taxpayers.
And it's probably also worth saying, and just in relation to this for our US viewers, that don't think the side-by-side is going to get you out. I mean, even if the side-by-side actually gets enacted, don't think it's going to get you out of the QDMTTs, because it isn't. Absolutely.
And just as a reminder for the US listeners, 2024 and 2025 compliance, they're not subject to the side-by-side. Right. And so US taxpayers have the same pain that the other taxpayers have to rely on. What can taxpayers do? I mean, can BIAC help? Can the OECD help? As we've traveled around together the last couple of weeks, we get lots of questions from taxpayers. Can we go to BIAC? Can we go to the OECD? Will they listen? But we feel past that. And now it's like we need to get to the 37 countries that have implemented these rules and have created this disparate web of global compliance to provide the relief that we need.
Yep. Well, look, I mean, so the answer to your questions is yes, you can go to BIAC, yes, you can go to the OECD, but the big question is, will that make any difference at this point? And the answer to that is no. I mean, you know, this is as good as the OECD can do. I promise you, if they could have done better, they'd have done better. So, you know, that's that. BIAC, you know, I was chair of the BIAC Tax Committee for 10 years. It's a great organization, but it can only sort of interact with the OECD on this stuff. And, you know, while it's done some good stuff, it's had some difficulties because of the way the project is set up. So, I mean, not to go off track too much, but, you know, if you think of the new simplified ETR safe harbor, it's not terribly simple. And BIAC, you know, gave that its best shot, but, you know, that's what we came out with. So what can businesses do? I mean, I've been very clear about this to anybody who's asked me now for a year or two, which is, you know, if you want to talk to the OECD, that's fine. Paris is a lovely place. But what you really need to do is to talk to national governments, because this is all in their hands. This is all, I mean, if there was a flaw of this, and it wasn't regarded as a flaw, this was regarded in some slightly Machiavellian ways as being the advantage of it, was you didn't need a big treaty for this, because you essentially were saying to countries, you can enact this individually. And that gave it its strength. You know, this was the famous critical mass of Pascal. If you got to a point where there were enough countries involved in it, having passed their own national laws, not worrying, having to worry about a big international convention or all the rest of that stuff, then it sort of took over. And so you need to go to national governments. You need to go to national governments because none of this stuff is covered by an international convention. There was an effort, right, I don't know, 2017, I actually got the UK to agree to the fact that actually some of these things, dispute resolution, needed to be covered by a treaty in order to be effective. Nobody else was buying, and we moved on.
Yeah. All right, so I want to highlight a couple of other pieces of guidance that have come out. I don't even, guidance is the right term, a couple of documents, how about, that the OECD has released. One was on April 30th, 2026, so 60 days before the compliance deadlines were due for calendar year filers, called the Global Minimum Tax Implementation Toolkit. And there is a lot of detail in there that is very interesting with respect to the technology that enables these various taxing authorities to accept returns, and whether they should outsource or build their own. I will note, without going into any of the detail, that this implementation toolkit specifically said that implementing jurisdictions should have their forms and filing deadline, their forms and filing portals open 90 days before the compliance deadline. So the toolkit came out 60 days before the compliance deadline.
Well, look, math is not my strong point, so I'm never going to criticize anybody for that, but it was a slightly odd way around, I would agree.
Yes. There's sort of negative 30 days, I think, is maybe you described that at one point.
Yep.
But, all right. And then the other document that I think has got lost a little bit in the noise was on May 18th. So along with this common understanding, the OECD released tax challenges arising from the digitalization of the economy. This is actually administrative guidance on the application of the transitional UTPR safe harbor to M&E groups with 52, 53-week fiscal years. This is a very small subset of taxpayers. I'm not going to go into any of the details, but frankly, if you're a taxpayer, this applies for U.S. multinationals that have a 52, 53-week year, and if that 53-week year was the same year that the UTPR safe harbor, so the side-by-side safe harbor that would have turned off the UTPR for U.S. multinationals because their year-end would have spilled over, effectively the side-by-side safe harbor would not have applied to them. And so this is, I've gotten several questions. This is very narrow. The taxpayers that were potentially subject to this, I think, all knew what the issue is. I think the rest of the world was like, what is this thing, this piece of administrative guidance? So it is very helpful for a small subset of U.S. taxpayers that had a 52, 53-week tax year. And I will also acknowledge one of my clients was in this, so I was very focused on this. And it is helpful, and it's consistent with the policy.
I agree with all of that.
So maybe we'll end things, Will, with I want you to look into your crystal ball, and it's foggy, I know, but like, how is this all going to work with dispute resolution? Because this is the other thing. It's like, okay, well, what happens when we're late with all these filings, and then what happens if we miss the deadlines to be able to elect transitional safe harbor? Any thoughts or anything with respect to how does the dispute resolution look like as we get past that first filing deadline?
Yeah. And also, I mean, what happens if there are disputes over the substantive provisions as well between countries? I mean, the whole thing is...
Oh, yeah, we haven't even gotten into the technical,
no,
open questions.
And let's not go into this. But I mean...
Because I got a list of those, too.
That is like hectares, acres of minefield.
Right.
Look, there has been some discussion of this recently. Like I said, there was some discussion back in 2017, but that got sort of deep sixed. But there has been some discussion recently, and an OECD official was talking at a tax conference, PACRIM, I think it was, last week before, whenever it was, and talking about this and saying that they were looking into designing a map-like dispute resolution procedure between countries. Go back to what we were talking about a little earlier, which is that I don't think that the OECD, sort of tries to mislead people about this. They just see the best possible course as the one which is going to happen. The trouble with this is that map-like is the key thing. These are not in treaties. There is nothing, again, legally enforceable about these. Individual countries will have to legislate this map-like solution for it to come into effect. That would take a very, very long time. And the number of Pillar 2 disputes by then, so let's assume it takes 5, 6, 7, 8, 9, 10 years. And the US, by the way, hasn't done any of these types of agreements in forever.
Right.
So it would take a long time for that to happen. And they acknowledge that that currently the the lack of a legal basis may be a problem for this. So, I mean, again, they're warm words. The sentiments are right, but the practical help for taxpayers is zero, basically.
So I'm going to leave us, Will, with an ask for both taxpayers that are listening to this, frankly, the other service providers,
Absolutely.
Technologists, technology companies that are trying to comply, and taxing authorities, because I know that we have taxing authorities that listen to this.
Yep.
We desperately need some real help, and not from the OECD, to your point, from each of these various taxing authorities to provide guidance from the 37 countries that have implemented these rules to create some pathway for waivers of penalties, for the ability to be able to do elections. We need help from these taxing authorities. And without that help, it's going to create so much uncertainty and risk and exposure for taxpayers. So we'll leave it at that.
Go talk to your governments.
Go talk to your governments, please.
Yeah. Great.
So thanks for tuning in to this week's episode of Cross-Border Tax Talks. Thank you, Will Morris, PwC Global Tax Policy Leader. I'm Doug McHoney, PwC's International Tax Services Global Leader. Stay tuned for another exciting edition of the Cross-Border Tax Talks podcast.
This podcast is brought to you by PwC, all rights reserved. PwC refers to the U.S. member firm or one of its subsidiaries or affiliates and may sometimes refer to the PwC network. Each member firm is a separate legal entity. Please see www.pwc.com/structure for further details. This podcast is for general information purposes only and should not be used as a substitute for consultation with professional advisors.